Conflict or cooperations? The implications of China's new fishing regulation. The new China's fishing regulation, which were passed by the Hainan province in 2013 and went into effect in 2014, has exemplified the growing assertiveness of China and intensified the heated South China Sea disputes. The South China Sea has been a productive fishing ground and full of aquaculture resources. Nonetheless, in recent years, fishing in the area has become a politically sensitive topic due to the geopolitical tension and security concern among the claimant states. This article intends to provide an analytical review of the current fight for fishing rights in the South China Sea and to offer possible solutions. The article argues that solving fishing disputes through multilateral cooperation rather than unilateral action in the South China Sea is an urgent task and a win-win solution. First, the article attempts to analyze the new China's fishing regulation and the impact on future multilateral cooperation in the South China Sea within the context of the 1982 UNCLOS and international law. It further looks into the implication of the burgeoning Asian economic integration for future joint action to conserve and manage marine resources in the area. Lastly, the article explains Taiwan's position in current South China Sea dispute and explores Taiwan's role in shaping a multilateral fishery management scheme in these disputed waters. The South China Sea, or SCS, which comprises a stretch of about 1.4 million square miles in the Pacific Ocean, encompassing an area from Singapore and the Malacca Strait to the Strait of Taiwan, spanning west of the Philippines, north of Indonesia, and east of Vietnam, is one of the world's most resource-rich regions. The CSC is also located on a major international shipping route between the Indian Ocean and Northeast Asia. This semi-enclosed area, as defined in Article 122 of the United Nations Convention on the Law of the Sea, or UNCLOS, is home to hundreds of thousands of marine species and encompasses a tremendous diversity of ecosystems. Its rich marine resources provide its bordering state with food security and serve as an important source of economic growth, contributing to income and employment. For example, it is estimated that the bordering countries of the SCS produce nearly a quarter of the world's caught tuna, including 3/4 of the world's production of canned tuna. The SCS has proved to be a productive fishing ground and is full of aquaculture resources. Nonetheless, in recent years, fishing in the area has become a politically sensitive topic due to the geopolitical tension and security concern among the claimant states. The bordering states have sought every opportunity not only to claim sovereignty in the territorial dispute, but also to fight for exclusive right to the rich maritime resources in the SCS. While vast benefits are generated by fishing in the SCS, the area's integrity is threatened due to destructive fishing methods, decades of intensive fishing, and marine pollution. The ongoing tension in the area have also hindered comprehensive surveys and cooperation schemes in the exploration and conservation of fishery resources in the region. According to a recent study conducted by the Asia Pacific Fishery Commission, or APFC, of the Food and Agriculture Organization of the United Nations, or FAO, China is by the far largest producer of captured fish in the region, representing 32% of total regional production. The same report also estimates that the majority of the stock or species grouping in the SCS subregion are overfished or fully fished. In some cases, the species group are even scored as depleted. The maritime dispute of the SCS are developing as areas of acute tension and political conflict. Nonetheless, the common interest of fishery conservation has often been overlooked. The lack of an agreement among the claimant states to manage jointly the fishery resources in the area has jeopardized the sustainability of the marine resources in the SCS. The new Chinese fishing regulation, which were passed by the Hainan province and went into effect in 2014, have exemplified the growing assertiveness of China and intensified the heated SCS dispute. Since the announcement of the new fishing regulation of the Hainan province, the regulation have been criticized as provocative by other claimant states in the SCS and the United States. The announcement of the new fishing regulation also raised concern about China's effort to exercise jurisdiction over all fishing activities in the disputed SCS. This article intends to provide an analytical review of the current fight for fishing rights in the SCS and to offer possible solutions. It argues that solving fishing disputes through multilateral cooperation rather than unilateral action in the SCS is an urgent task and a win-win solution. Despite the complicated territorial claims, the unity of Asian countries within the increasing Asian economic integration provides a good opportunity to induce China to form a cooperative framework for marine resource management in the disputed area. First, the article attempts to analyze the new Chinese fishing regulation and its impact on future multilateral cooperation in the SCS within the context of 1982 UNCLOS and international law. It further looks into the implication of the burgeoning Asian economic integration for future joint action to conserve and manage marine resources in the area. Lastly, the article explains Taiwan's position in current SCS dispute and explores Taiwan's role in shaping a multilateral fishery management scheme in these disputed waters. The new Hainan fishing regulation. The Hainan Provincial People's Congress amended the Hainan Province Implementation Regulation of China's National Fishery Law on 29 November 2013 and they took effect on 1 January 2014. The new Hainan fishing regulation were passed in to implement China's national fishery law in the province of Hainan. Article 1 of the Hainan Fishing Regulation states that one of the main purposes of the regulation is to secure and enhance the conservation and exploration of fishery resources in accordance with the rules under China's national fishery law. This provision of the new Hainan fishing regulation echoes the statement in Article 1 of China's national fishery law. It shows that the law seems to be formulated for the purposes of enhancing the protection, development, and reasonable utilization of fishery resources, developing artificial cultivation, protecting fishery workers' rights and interests, and boosting fishery production so as to meet the requirement of the socialist construction and the needs of the people. The scope of the regulation and the fishery. Do the regulation cover the South China Sea? Although China hasn't been able to provide concrete statements to support its territorial and maritime claim, referred to as the U-shaped line or dashed line in the SCS, China has still been insistent of its jurisdiction in the area. In the new Hainan Fishing Regulation, Article 2 defines the scope of application of the new regulation. It provides that the fishing regulation apply to the method of fishery production, management and conservation, and other fishery-related activities conducted in the internal waters, tidal flood, and all other maritime areas within the jurisdiction of Hainan.